Just say where we are and where you're from.
My name is Lauren Holt. I'm from Dallas, Texas.
I'm Karen Reedy, also from Dallas, Texas.
I'm Harlan Michelle. I'm from Lake Oswego, Oregon.
And I'm Noah Ha, also from Lake Oswego.
Okay, could you the coaches just introduce yourselves also because the coaches are very important. I want to make sure you guys get credit.
Garrett Kevin, Lake Oswego High School. Jonathan Carteret, Creekview High School in Carrollton, Texas.
Very good. I'm Josh Blackman. This is my 13th year doing this. It's an honor. It's a pleasure. So we will begin in a few moments. Judge Rao will call the case. Any questions before we get started? We are being recorded. The cameras are in the ether, but the cameras are rolling. So whenever you're ready, I won't detain you longer. Oh, sheets. You attend, Judge?
We have a clock.
I'm going to do the clock. I got right here.
Oh, I can.
So, yeah, you'll see it. So whenever you pull the case, I'll start it off. Okay.
You can watch.
Okay. So today we are arguing the case of Free Speech Coalition versus Paxton. Presiding are Judges Rao, Judges Lambert, and Judges Solomson. You proceed. Your timing. Stop your clock again.
Whenever you're ready.
Thank you, Chief Justice and Associate Justices, and may it please the court. My name is Noah Ha, and along with my co-counsel, Harlan Michelle, we represent the petitioners in this case. Following an appeal of the preliminary injunction, a Fifth Circuit majority has decided to hold Texas House Bill 1181, a bill that heavily burdens adults' access to constitutionally protected speech, the mere standard of rational basis review, the least restrictive form of scrutiny available.
We disagree with this, Your Honor, and we point to Justice Scalia's writing as one of our central tenets. Writing his opinion in Brown versus Entertainment Merchants Association, Justice Scalia made a salient point that, quote, regardless of modernity or context, the basic principles of freedom of speech and the press that the First Amendment commands do not vary, end quote. Despite the challenges of novelty, this court has come to the defense of these rights again and again in an unbroken line of precedent. In Reno, in Ashcroft, even as far back as Butler versus Michigan in the 50s, and against a long line of content-based impositions more coherent and logical than this bill.
This bill in particular faces multiple red flags that were fatal to its predecessors. A blanket ban speech under the vague content-based imposition of harmful to minors, borrowing language directly from the CDA and COPA, which were both ruled unconstitutional. It mandates websites talk about ostensible health warnings with a clear subjective tilt and that go against the website's commercial interests. This bill paves the way for even more subjective laws in the future that dictate what Americans can or can't see and say online. A future where sexual education materials, books, blogs, websites all come under purview of state legislators is frightening, Your Honor.
As my co-counsel mentioned, refusing to reinstate this preliminary injunction paves the way for a world in which subjective laws carve constitutionally protected material into piles of good and bad speech based on perceived social cost, but not their constitutionality. This decision defies overwhelming precedent from this court and threatens the future of First Amendment protections. This court should find that the Fifth Circuit's decision is erroneous, take action to restore the preliminary injunction based on strict scrutiny review. Content-based impositions on free speech are presumptively unconstitutional and require strict scrutiny review. Thank you, and we welcome questions from the court.
So, if Texas's law's primary aim here is regulating the access of minors, consistent with the Ginsburg decision, why does the standard automatically be strict scrutiny simply because adults are trying to access the website?
We can see in cases like Reno, for example, that even if the intention is to restrict minors' access, it still cannot significantly burden adults' access. And if it does, it must then be reviewed under strict scrutiny.
We have to look at the impacts. At least 29 million Americans don't have government-issued ID, which places them at a real disservice when they're trying to access this material. One of the main proprietors—
Access pornography?
Yes. One of the main proprietors, Pornhub, for example, has pulled out of 17 states so far. That's a real chilling effect. These Americans are now unable to access that material. It's their right to do so.
Is this really a content-based restriction, though? It's not restricting any of the speakers. It's just restricting access. It's like restricting access to cigarettes.
It is, but we have to look at the impact that company has pulled out, for example, and because of the way it determines which websites fall under this violation, the 1/3 content-based, that's a content-based restriction. That's kind of what the main issue is.
The language is materially identical to that in COPA with the term sexual material harmful to minors, which is a clear content-based imposition.
is it a content-based restriction on speech or just on conduct, which is the conduct of accessing these websites? Does that make a difference? Or the standard?
Sorry, yes, it's speech when we, again, look at the consequences. Previous cases have delineated a difference between, a minor's right to this material and an adult's right to this material. But some of the chilling effects are real and severe. I mean, what's proposed in this bill is providing a government-issued ID, for example, that and with a small fine of $10,000, for example. I know many Americans who really reconsider whether or not they want to access this material, putting personally identifying information onto the internet in a black box. Who knows where that goes? That's a real risk that many people will consider seriously when they're trying to access this material. Many Americans don't even have the proposed mechanism to do that.
Doesn't that get to the question of whether or not the law is constitutional as opposed to what level of scrutiny applies? That's the cart before the horse. What's the test for the level of scrutiny?
The level of scrutiny is that it's as stated in Justice Thomas's opinion. But content-based restrictions are presumptively unconstitutional. It must always be reviewed under strict scrutiny. And we can see this in the long line of precedent from Sable, Playboy, Reno, and Ashcroft.
In the Child Online Protection Act, in Ashcroft 2, for example, it was this exact term, harmful to minors, that got that law struck down as unconstitutional. It's so vague and so subjective. And similar courts have struck similar laws. Federal district courts, for example, in 2023 and 2024, in that Choice LLC versus Griffin, for example, have struck laws that attempt to do this kind of thing, use these broad blanket terms to ban material that, let's be real here, is socially taboo or socially uncomfortable. We believe that's the real issue at hand here, not the constitutionality.
In the earlier laws texts, was that regulating the production or distribution of the content as opposed to access? Or was it regulating access?
Some of them regulate access, like Sable, for example, regulated who can access these dial porn services, for example, and some of them, like the Child Online Protection Act, have tried to do similar things as far as regulate who gets that content yet. But it's the consequences that we have to look at as opposed to, necessarily what the intentions of the bill are.
Additionally, with this bill, we have to consider not only the people viewing the content, but also the speaker-based burden that's associated with largely the cost of verifying all of the users is a significant cost that many of these smaller companies are unable to burden. Then,
if we were to determine that strict scrutiny did apply, do petitioners have any other thoughts about how a law like this could be more narrowly tailored?
Sure, we can use a variety of ways. One of them is content filtering. I know this court has kind of been uncomfortable with content filtering as far as its efficacy, but we believe it's a real method that Texas needs to explore here. There are so many issues with this bill as far as adults accessing it and this mandated speech, which we've only touched on. That's pretty unconstitutional. This court has precedent against that in National Institutes of Family and Life versus Becerra, 303 Creative LLC versus Atlantis, for example. We're stipulating that these companies have to actively work against their interests. That's another unconstitutional component. So yes, in a different world in which the information was delivered instantaneously, like in Ginsburg, for example, where we had a subjective determination of age, that information, that ID wasn't kept for more than that small transaction, then that would be a different world. But that's not the one we're considering with this bill, unfortunately.
If modern science determines that the product of pornography is every bit as dangerous as cigarettes, why don't we just call that a commercial product that's capable of regulation? Why put it in the speech bucket at all?
well,
Because it is speech. It's not necessarily a digital good. You can purchase and consume it, but it is speech. Harmful to minors, for example, if this bill were to be held up, could encompass anything from a Planned Pregnancy website or Planned Parenthood, for example, in which parents wanted to sit down with their kids and work with them to learn about sexually transmitted diseases, for example, or a variety of other things. So yes, it's an uncomfortable topic, and sure, there is science out there that says it may be biologically destructive or harmful to somebody's brain, but we still have to look at the real consequences. This is something adults are able to access, able to consume, and able to produce. As far back as Shakespeare's plays, stuff like this has been around.
But I think it's interesting that the petitioners rely on McIntyre for their argument about anonymous speech, because I wonder if the material here, which is pornography, is the anonymous consumption of pornography, does it have the same type of speech interest as the political pamphleteering in McIntyre?
absolutely. Accessing this kind of content is a very personal thing that is, and by reducing the anonymity of it, it creates a massive chilling effect that's not present normally. And this is what significantly burdens the adults' access.
And you think that is as strong of a First Amendment interest as political pamphleteering?
It's not our position to say whether or not accessing this material or distributing it is necessarily strong or weak. All we're attempting to prove here is the unconstitutionality. Yes, it may be an uncomfortable topic, but what somebody does in their house or, in their private time is not at the jurisdiction of this court, nor should it be. These subjective laws have real potential to, again, determine large swaths of content, good or bad, just on how uncomfortable they make us seem as we debate them here today, for example.
I'm still troubled by that. I think Judge Rao's question was not the chilling effect, but the underlying, right? But we can agree that maybe the lack of anonymity is the same level of chilling effect in both cases. The question is whether the underlying content is more deserving or equally deserving of protection as political speech. And you're saying we shouldn't consider that at all. That once it's speech in the sense that somebody is speaking or producing something that someone might label as art, then strict scrutiny kicks in.
I don't believe that's just a claim we are making. I think that this court has ruled again and again that the extension of protection of speech goes far beyond just political speech, including speech that is considered sexual content.
But it doesn't include obscenity.
It does not.
It does not.
But that,
Why do you argue that this content is not kind of directed towards the prurient interest? I mean, I just didn't understand that at all in your brief.
We acknowledge that some aspects of pornography are absolutely directed towards the prurient interest, but those that are not found to be obscene should be protected. Just because it's a new digital medium doesn't mean it's any less deserving of protection. Again, in Brown versus Entertainment Merchant, this court considered violent video games, which one parent may concede to be just as taboo or just as improper as pornography, but one parent may not. Just because this material is in this new and novel context doesn't mean it's any less deserving. Obscenity is a different argument. We concede that obscene material should not be protected, but non-obscene pornography is what we believe Americans have a right to access, right to distribute, and right to consume, free of these very real and concerning chilling effects.
How do we decide what's non-obscene pornography? Is all pornography not obscene?
is it all right if we continue?
Yes.
Sorry, maybe repeat the question.
Is it, how do we know what pornography is not obscene?
Well,
Is there non-obscene pornography?
Absolutely. Well, it's not the question present. When we consider how obscene pornography is, we need to consider the community standard of the internet today, which is a diverse place with many, many different viewpoints and ideas, and holding that entire internet to a very limited standard is an impossible task, Your Honor. And if it was clear that pornography was obscene, then we would not be able to even have websites like this at all. And clearly, these websites are a large part of our society, a large part of our world, and are very present and active.
Okay. Thank you. 15 minutes for the respondent.
May I proceed?
Thank you. Madam Chief Justice Rao, Associate Justices Solemson and Lamberth, and may it please the court. The Constitution does not entitle pornographic expressors to an audience of minors.
Nor does it entitle adult consumption to pornographic material in a time, place, and manner that is harmful to minors.
My name is Harlan Reedy, and alongside my co-counsel Lauren Holt, we represent the respondent, the state of Texas in today's case. The question before the court is what standard of review Texas's HB 1181 should be analyzed under. And this court should find that the Fifth Circuit was correct in employing a rational basis review as adherent to Ginsburg versus New York. None of the petitioner's justifications show that this law rises to the level of strict scrutiny. However, even if this court found it did, then HB 1181 would pass under a strict scrutiny review, because this is a narrowly tailored law that meets a compelling governmental interest. And because this is a facial analysis brought before the court, the respondents would prevail, because the petitioners have yet to show it is unconstitutional in every single one of its applications.
Further, petitioner's argument relies on 3 key points in determining to look towards strict scrutiny. First, they argue that anonymity is a crucial part of the First Amendment. Secondly, they argue this is a content-based regulation. And lastly, they argue that in their brief, it is identical to COPA, the law at issue in Ashcroft. When analyzing their first argument that anonymity is a crucial part of the First Amendment, if we look toward a question presented by Justice Rao earlier, that certainly political pamphletity is definitely different than what is happening today. And if we look toward the brief presented by the petitioners, they rely on McIntosh and Talley for their argument for anonymity, of which are both political speech cases, and are differ from the cases at issue today. When we look toward the second argument presented by petitioners of the content-based regulation, in today's case, we should look toward Hamling, where they found that just because a law requires you to look toward the content of something determines obscenity, and that does not make it a content-based regulation. And instead, they should find that HB 1181 is an age-based regulation, and that this law differs substantially from COPA, as COPA was decided during significant technological limitations of 2004, and COPA was significantly overbroad, of which HB 1181 is not.
We welcome the court's questions.
I mean, that was actually going to be my first question, is how precisely we do distinguish the restrictions that the court found unconstitutional in Ashcroft from the restrictions in HB 1181.
Yes, Your Honor.
Speak more specifically to that.
Yes, Your Honor. So there's 2 main distinctions here. First is the law in Ashcroft did not have a specific threshold for what companies should apply to this law, whereas conversely, in today's case, we have a 1/3 or more threshold. So the law was exceedingly overbroad and unclear on how to apply the Miller test, and especially the third prong of the Miller test.
So 1/3 or more of
1/3 or more revenue from these if they get 1/3 or more of their revenue from pornographic material. And so here we have that clear threshold, so it's not overbroad as it was in Ashcroft. And the second limitation is that the second distinction is that there were significant technological limitations at that time, where it was unfeasible to get an ID to purchase a credit card or to get a credit card in order to purchase an ID and have this kind of verification.
Further, petitioners in today's case argue that 26,000 Americans do not have an ID. However, HB 1181 does not necessarily require an ID for age verification. Simply, it requires something that's verifiable, such as a credit card, of which most Americans do have. If someone simply enters their credit card through a third-party system such as Yoti, that would be sufficient to meet HB 1181's requirement, even if they don't have a government-issued ID.
The key here is that it must be a commercially reasonable method. We can see this has already worked in other cases, such as Yoti, which is a third-party age verifier, and they do this on the app OnlyFans. They say, okay, you can submit a picture of your ID, your cable network, your biometric facial scan using AI. We can see there's significant technological advancements since the time of COPA and Ashcroft 2 that makes this law have a significant distinction. And again, it should fall under a rational basis review, because we're not restricting adults' rights to this pornographic material. Instead, we're simply saying.
So with respect to the standard of review, though, I mean, Ashcroft, the law was similar. It may not be exactly the same, but the court applied strict scrutiny. So why shouldn't that be the test here?
Yes, Your Honor. It is respondents' contention not to apply strict scrutiny as we did in Ashcroft because of these differentiations. While they are not the exact same, it is because of these differences that allow for the court to look towards strict scrutiny.
Furthermore, we can look to Ginsburg versus New York for the control.
Wait, what are the differences?
Yes, Your Honor. As argued earlier, when it comes to here, there is a 1/3 or more threshold of which was not there in COPA. Further,
That's just to whom or to what companies the law applies.
Yes,
yes.
Okay, that has nothing to do with the nature of the speech or what has to be done to get access to the material, right?
Yes, Your Honor. One of the biggest problems in Ashcroft 2 was that they were unsure on what companies had to apply to this law and how to apply the third prong of the Miller test, what had significant literary, political.
Question about whether it passes strict scrutiny, not whether strict scrutiny applies in the first instance. I mean, given the similarities between the laws, why shouldn't the standard of review that we apply be the same? I I mean, perhaps this law passes strict scrutiny, but why shouldn't the standard be strict scrutiny?
Yes, Your Honor. So the difference here is that in Ashcroft, they were restricting adults' rights to this kind of material, whereas in today's case, they're not. It is essentially the digital version of Ginsburg, where we said, okay, we can have an ID verification when it comes to protecting children from harmful material. There, the court said there must be a bona fide attempt to ascertain the true age of its customers, and that's exactly what the law before the court is today. We're simply saying that adults can still see this kind of material as long as minors do not.
And because Ashcroft was decided in 2004, where there were significant technological limitations, the burden on adults would have been too great as to not require strict scrutiny. However, today, where most adults have a credit card or some way to verify their age through third-party systems such as Yoti, that same kind of limitation does not exist, and thus the court must apply rational basis.
Further, Your Honor, Justice Solemson asked the petitioners, what precedent do we look at for the standard of review in today's case? And that is exactly what we should look to Ginsburg for this exact reasons, because it is very similar to the case at bar. And while this is an online case, it still has the same founding principles and it still has the same ID verification measures. And if we turn this court's attention to their content-based regulation, they're saying that, well, because we have to look at the content and because it aligns with cases in their brief, such as Reed versus Town of Gilbert, it should trigger strict scrutiny. However, this is not a content-based regulation, but an age-based restriction, where we're not saying that we're not regulating what these commercial publishers may produce, as it has been historically. Instead, we're simply saying who may view this material.
Do you view the regulation as imposing a limitation on the conduct of people who access these sites, as
Yes.
opposed to a kind of speech regulation?
Yes, Your Honor. It is respondent's contention that it's more of a conduct regulation and age verification, not a content regulation of what they may say. Simply that we're ensuring that those who access pornographic material are over the age of 18.
Isn't there a warning label requirement too in the law?
Yes, Your Honor, but that issue is not on appeal in today's case. The compelled speech issue that they argued, we are not here to argue before the court, is most certainly unconstitutional. But in terms of what is before the court, we can see that it does fall under a rational basis review, because we don't have this kind of restrictions on adults' rights to access this material. But even if this court finds it rises to a level of strict scrutiny, this law would pass because it is a narrowly tailored law that has a compelling governmental interest in protecting children, one that both sides have agreed, again, is compelling.
I wonder, if we apply strict scrutiny, is this law really narrowly tailored to meet the government's interest? I mean, I believe petitioners concede that the government has an important interest in protecting minors from pornographic materials. So that's not an issue. So what we're really focused on is narrow tailoring. And here it seems that perhaps there could be more narrowly tailored means of reaching this end.
No, Your Honor, Chief Justice Rao. Respectfully, there are no narrowly tailored means that would meet the interest compared to HB 1181. While petitioners do sort of have parental controls as a means, Playboy specifically rejected parental controls. Further, when it comes to content filtering?
Further, with content filtering, we have seen over the past 20 years, and they even conceded there's issues with its efficiency and its effectiveness, because the Department of Justice recently conducted an investigation which found that 25% of harmful material on these websites, when subject to a content filtering restriction, did not actually get restricted off, so minors could still see this material. But conversely, 20% of material that should have been protected for both adults and minors was not filtered off of these platforms.
There's a much different showing effect. If you want to buy cigarettes or alcohol, you show an ID and you get the product, but the vendor doesn't retain your identification or your, otherwise maybe private information about what your purchasing habits are. That's not the case here.
Your Honor, actually, it is significantly the case when it comes to the sort of retaining information. House Bill 1181 specifically penalties civil companies in a civil matter if there's any retention. It's $10,000 per instance of retention. So these companies cannot retain the information that is projected toward them.
So it's not merely that it doesn't require retention, it prohibits retention.
Yes, Your Honor, it makes it unlawful to have this kind of retention. And so it shouldn't be found that this is more burdensome or that this has more chilling effects in Ginsburg, because there they couldn't retain this kind of information either.
Further,
Does your argument depend on the fact that, does your argument depend in any way on the fact that this information, that pornography is entitled to less First Amendment protection than other speech than, say, accessing the New York Times or the Wall Street Journal online?
not significantly, Your Honor, simply that pornography is not entitled for children to view, and that it's only entitled for adults. And as long as adults aren't significantly burdened to access that material, then then the law is constitutional. It should be reviewed on a rational basis.
And we agree with Your Honor's question to them earlier that we should look at this more as a commercial product instead of one about the regulation of speech to adults or the restriction of speech to adults. Simply, we're saying that they can still see this kind of commercial product, but that minors cannot see this because it has such detrimental effects.
Further, in response to Justice Solomon's question earlier, petitioners argued that if we were to find HB 1181 constitutional, then it would significantly ban sort of teaching sites such as Planned Parenthood, and that parents who wanted to teach their children about anything that had to do with any sort of pornographic content, that would be banned under HB 1181. However, this is simply inconsistent with House Bill 1181's functionality. House Bill 1181 does not allow for the sort of prohibiting of learning material. It only allows for those that are for the prurient interest, and is very specific on what that is.
And so teaching websites that include material about human sexuality would not be included.
No, Your Honor, if these websites don't have 1/3 or more pornographic material that would be found indecent to minors under the Miller test.
Is that a vague standard? I mean, what's pornography? We know it when we see it.
Yes, Your Honor, under Pacifica, they did say that sort of when the pig enters the room, when you see it. But there's always going to be sort of a subjective small scale when it comes to someone's decision on what to determine is more pornographic than another. However, this subjectivity does not outweigh the interest in protecting children. When it comes to the pornographic material here, such as that's presented in companies such as Pornhub or OnlyFans, the court can agree that certainly that's the prurient interest.
Furthermore, if we look to the standard in Miller versus California, that sets out what is indecent for minors in today's case. Now, that was the test for obscenity, but in this law, we have drawn it closer to indecent for minors. And Ginsburg used the same exact test before they called it the Miller test. 1, whether it appeals to the prurient interest. 2, whether it is patently offensive. And 3, whether it lacks significant literary, artistic, scientific, or political value. And so if any of this information or if any of these companies host this kind of information with this value or without any prurient or patently offensive language, then it would not fall under the law, thus making it exceedingly clear.
Sounds like under that test, we do have to consider the merits or the value of the underlying content, whether it has any political value or artistic value, or is it's unavoidable that the court consider, that what the quality of the subject matter is.
Well, Your Honor, to some extent, they do determine under the Miller test what's considered obscene, but that doesn't make it a content-based regulation. It's simply an age-based verification. When it comes to what is being regulated, it's not simply stopping them from regulating certain things, but stopping them from producing certain things under their content, but simply allowing for the courts to regulate who views it.
Further, if we look to precedents like Renton and Pacifica, if we want to raise the bar from rational basis, we can go to kind of a deferential standard of review, where they said, and the petitioners agreed, there might be secondary effects on children. And in Pacifica, they said, we cannot allow this to happen. And when there is this kind of subjectivity towards what value it has, then we should look towards an intermediate scrutiny if we're really that concerned about it. And if there are no further questions, it is for these reasons we respectfully request the court rules in favor of the respondents. Thank you.
Justice Rao, Justice Lambert, and Justice Samuelson. We would like to respond to 3 main points from the respondents' argument.
Number one, our friends on the other side's claim this is essentially a time, place, and manner restriction instead of a content-based imposition. Number two, the means issue about how we actually go about verifying people's age and all the issues associated with that. And number three, whether or not Ginsburg is in fact the controlling precedent here. To begin with that first point, our friends on the other side elaborated that essentially this is a time, place, and manner restriction and that we're not really preventing adults from accessing the material that they're entitled to. But consider, for example, a high-profile politician who is trying to access this material. They would seriously reconsider forking over their ID, their credit card, or other personally identifying information when they access the material. The second they choose not to, because of those associated risks, we're essentially separating the consequences from the intent here. That is what a content-based restriction on somebody's access to free speech looks like. Our friends on the other side have tried to acknowledge that this may be a commercial product as opposed to speech, but again, that determination, which our friends conceded, harmful to minors, can cover everything in reality. We hope that's obvious to this court, from a Planned Parenthood website to softcore pornography to an education film, anything somebody.
Seems like it seems like you're just going all the way to the bottom of the slippery slope there. The way that the bill is designed, is it really going to sweep in websites that are, educational or talk about human sexuality generally that are not pornographic? I'm not sure why we would assume that those sorts of websites would be included.
While Texas might just be stopping at pornographic websites now, the language in the bill includes the details and specifically specified sexual content, but could be expanded in the future to anything that the Texas legislature claims to be socially not up to their standard.
We have to acknowledge the bottom of that slippery slope, unfortunately. It's when we're considering, again, separating the consequences from the intent. Yes, we acknowledge the government's rational interest in protecting these children, but we have to consider what may happen if we allow similar laws like this to go into effect and continue to bounce around in the courts.
Sorry, what can the state do to protect children then?
Something rational.
Content filtering, but how would that work as a statutory mandate on parents, on computers sold to children? They have to have hardwired content filtering.
There are a lot of alternatives out there. We could look at content bans on public spaces, for example, to begin with, like libraries, which has been found constitutional by this court. We could look at device-specific IP regulations. We could look at apps. All we're attempting to elaborate here is how many flagrant issues there are with this specific bill. And as Chief Justice Rao mentioned at the bottom of that slope.
You're saying the state then cannot constitutionally determine that pornography is like a cigarette or alcohol?
Sorry, may you please repeat the question?
I just want to know why the state can't rationally determine that pornography is similar to alcohol or cigarettes and ban children from accessing it. And if they can, how would they do it?
Well, what we would look at for that is let's go to a case like Sable, where it determined that material can be considered obscene as to minors, but not as to adults. So it creates that standard where the state can restrict children's access to this content, but not adults. And in this case, since
But they
adults,
can restrict it, but they just can't enforce the restriction.
they would be able to enforce the restriction, but as it burdens the adults' access, then it must be reviewed under strict scrutiny. This is
If you're drawing a line, that's true for any of the products that Justice Solomson mentioned, right? Adults are, arguably burdened when they have to produce ID to purchase cigarettes or alcohol or many other things that require an ID. To get a cell phone, to, open a bank account. You need ID for all of those things.
The simple answer to that is that none of these things are speech, and they don't have a long line of precedent of requiring strict scrutiny when they are regulated based on their content. The regulation for alcohol and cigarettes is all on a rational basis term.
And this is exactly why we believe Ginsburg isn't the controlling precedent here. Yes, if we want to create a different standard for minors, that's fine, as long as it doesn't rationally impose on an adult's access. We look at Ginsburg, that's a subjective determination on someone's age, right? Flashing an ID card, a 10-second interaction that doesn't retain that information, that doesn't risk blackmail or all the real and costly privacy risks that create a chilling effect.
I still haven't heard one example of how we can restrict minors from accessing in a way that you would be happy with.
We could look at apps like Yoti, for example, but as our friends,
what would that do?
That would
it would determine the age of the users, but not retain any of the information. But the issue is that this Texas law provides no assurance, no structure for punishments or what would happen to companies if they leak or misuse this information.
Nor does it stipulate that apps like that have to be used. Our friends on the other side have mentioned that we just have to use something reasonable or some reasonable commercial way of verifying somebody's ID.
So if the statute mandated a use of a type of app and the statute described how that app functioned, you would be okay with that.
That would fix some of the issues with this bill, but we haven't even touched on the mandated speech, which our friends have acknowledged is flagrantly unconstitutional as well.
The mandated speech to list the warnings.
Yes, with a clear subjective tilt that works against the company's commercial interest, essentially telling people not to use their products even though they're the people profiting off.
And you view that as kind of compelled speech.
Yes.
We ask this court to find that this law should be reviewed under strict scrutiny. Thank you.
Thank you.
Thank you both counsel. Case is submitted.